topic of waterfall mechanism under IBC, and to deliver the session on the same, we have with us Deepika B. Prasad, ma'am. On the behalf of ICICI IIP, I welcome you, ma'am, for this session. And I would like to introduce you. Ma'am is a qualified cost and management accountant and an insolvency professional. Ma'am is currently associated with AAA Insolvency Professional LLP, appointed as a designated partner. She has a vast experience of over 24 years in management consulting, financial modeling, business restructuring, and costing assignments with India's renowned organizations. Ma'am has also been a regular speaker in various forums as well as in our institute as well. Ma'am, I would like to request you now to begin with the session.
Thank you so much. Thank you for giving me this opportunity. Good afternoon to all the members. I think we can today now start this discussion on waterfall mechanism under IBC. So at the outset, I would just like to just say that I have a little bad throat today, but I'll try my best to just do justice to this session. And we'll just start with this waterfall mechanism under IBC. So insolvency, I'll just introduce a bit of this session. That IBC code, it came into existence to govern the easy exit of businesses. And it has been witnessed from time to time that India has been lacking the legal framework for the companies whose businesses have been hindered and they want to exit the market. Also, it had also been a matter of concern to determine the order of distribution of assets at the time of liquidation of the company. So previously, there were no specific provisions to govern the distribution of assets amongst the creditors. But in the present era, Section 53 of the IBC Code 2016 deals with the mechanism for the distribution of assets under liquidation. Now, we all understand here the IBC Code and we all understand how the things are worked out. But now we'll go into the nitty-gritties of this waterfall mechanism under IBC. So this mechanism has been laid down under the code and it is termed as the waterfall mechanism. In general sense, the waterfall mechanism put the list of stakeholders in a sequential manner to indicate the priority in getting the payments from the liquidation. However, there are no express provisions in the code that clearly defines the priority of inter se secured creditors who have relinquished their security interest. We'll just go a bit into the historical perspective of this. So at the time of insolvency proceedings, the inter se ranking amongst creditors plays an important role as it dictates the arrangement and determines the priority in which the financial offerings by the resolution applicant shall be distributed to the secured creditors. Now, the status of determining the priority was different in the pre-IBC regime and post-IBC regime. We'll just go a bit into it. In the pre-IBC regime, the Supreme Court of India, in the case of ICICI Bank versus Sidco Leathers Limited and others, addressed the issue of priority under sections 529 and 529A of the Companies Act 1956, which govern the ranking of creditors' claims in a company in liquidation, which is similar to section 53(1)B of the IBC Code 2016. In this instance, the Supreme Court interpreted the meaning and scope of Section 48 of the Transfer of Property Act 1882. We'll go into the details of each aspect of this, and the first charge holder's claims would persuade over the second charge holders. This also we will come to in a detailed discussion in the forthcoming slides. So to begin with, we'll just quickly have a look at the Section 53, which is the distribution of assets. Now, Section 53(1) says that notwithstanding anything to the contrary contained in any law enacted by the Parliament or any state legislature for the time being in force, the proceeds from the sale of the liquidation assets shall be distributed in the following order of priority and within such period and in such manner as may be specified, namely, number one is this, the insolvency resolution process costs and the liquidation costs paid in full. The following debts which shall rank equally between and among the following. The workman's dues for the period of 24 months preceding the liquidation commencement date and debts owed to a secured creditor in the event such secured creditor has relinquished security in the manner set out in Section 52. This is 53(1)A and then B And these are the parts of 53(1)(b). And then we come to 53(1)(c), which is wages and any unpaid dues owed to employees other than workmen for the period of 12 months preceding the liquidation commencement date. We'll just come to a little bit of it again. This is the IRP costs and the liquidation costs paid in full. So this is paid in full. This is something we need to remember for the rest of our presentation. The next thing is the debts which shall rank equally between and among. So these are the two priorities which are there. And then wages and unpaid dues owed to employees other than workmen for the period of 12 months preceding the liquidation commencement date. Then financial debts owed to unsecured creditors, that is D. Then E is the following dues shall rank equally between and among the following. Any amount due to the central government and the state government, including the amount to be received on account of the Consolidated Fund of India and the Consolidated Fund of a state, if any, in respect of the whole or any part of the period of 2 years preceding the liquidation commencement date. And then the debts owed to a secured creditor for any amount unpaid following the enforcement of security interest. And then F is any remaining debts and dues. Now we'll go into the details of each aspect of these. After this is the G part, which is the preference shareholders, if any. And then H is equity shareholders or partners, as the case may be. Then the 53(2) gives a writing provision which says any contractual arrangements between recipients under subsection 1 with equal ranking, if disrupting the order of priority under that subsection, shall be disregarded by the liquidator. Please give me one second. I'm sorry about this. Please excuse me. So any contractual, now this is a riding provision, a riding clause, any contractual arrangements between recipients under subsection 1 with equal ranking, if disrupting the order of priority under that subsection, shall be disregarded by the liquidator. Then 53(3) says the fees payable to the liquidator shall be deducted proportionately from the proceeds payable to each class of recipients under subsection 1, and the proceeds to the relevant recipient shall be distributed after such deduction. Now let's just further, there is an explanation for the purposes of this section. It says that it is hereby clarified that at each stage of the distribution of proceeds in respect of a class of recipients that rank equally, each of the debts will be either paid in full or will be paid in equal proportion within the same class of recipients if the proceeds are insufficient to meet the debts in full. Now, this is very important. Like I just said, that we can go to the 53(1)(a), which says that the insolvency resolution process costs and the liquidation costs paid in full. So this is the first thing which needs to be paid out of the proceeds under liquidation, which is the insolvency resolution process costs and the liquidation costs, which need to be paid in full. Further, the next provision, which is, it says that at each stage of the distribution of proceeds in respect of a class of recipients that rank equally, each of the debts will either be paid in full or will be paid in equal proportion within the same class of recipients if the proceeds are insufficient to meet the debts in full. Now, this is where the whole mechanism comes into play, because the 53(1) says that the liquidation costs and the CIRP costs will be paid in full as per 53(1)(a). The rest of them will be paid as per the available proceeds, and they have to be paid in equal proportion within the same class of recipients. Now, this is where the discussion and the problems emerge, and this is where the decision of the liquidator and the decision under the waterfall mechanism will have its play. So we'll now come into the detailed discussion of this topic, and further the term workman's dues shall have the same meaning as assigned to it in section 326 of the Companies Act 2013. Now, what is this waterfall mechanism under IBC? The waterfall mechanism lays down that at the time of the company's liquidation and while distributing the assets of the company, the secured financial creditors shall be given the priority and the amount belonging to them shall be paid fully according to their admitted claim before initiating any distribution to the unsecured financial creditors. Now, this is a waterfall which is, as per the entire section 53. Here we need to understand two more issues. One is the liquidation estate and one is section 30, where the resolution plan details are also given up. Now, if we come to the liquidation, we need to understand the liquidation estate here, because we are talking about here the distribution of the funds which are derived from the liquidation estate. Now, this liquidation estate as per section 36 comprises of the liquidator shall form an estate of the assets mentioned in section 36(3), which shall be called the liquidation estate in relation to the corporate debtor. Liquidator shall hold the liquidation estate as a fiduciary for the benefit of all the creditors. Now, CRRP costs due from secured creditors who realize their security interests in the manner provided in this section shall be deducted from the proceeds of any realization by such secured creditors, and they shall transfer such amounts to the liquidator to be included in the liquidation estate. So now, this is again included in the liquidation estate. Now, what is included in the liquidation estate assets under the IBC? Subject to section 36(4), the liquidation estate shall comprise all liquidation estate assets, which shall include the following: any assets over which the corporate debtor has ownership rights, including all rights and interests therein, as evidenced in the balance sheet of the CD, or an information utility or records in the registry, or any depository recording securities of the CD, or by any other means as may be specified by the board, including shares held in any subsidiary of the corporate debtor. Further, assets that may or may not be in possession of the CD, including but not limited to encumbered assets, tangible assets, whether movable or immovable, then intangible assets, including but not limited to intellectual property securities, including shares held in a subsidiary of the CD, and financial instruments, insurance policies, contractual rights. Assets subject to the determination of ownership by the court or authority. Any assets or their value recovered through proceedings for avoidance of transactions in accordance with this chapter. Any asset of the CD in respect of which a secured creditor has relinquished his security interest. Any other property belonging to or vested in the CD or at the insolvency commencement date, and all proceeds of liquidation as and when they are realized. Further, what is not included in the liquidation estates? There are a few items which are not covered under the liquidation estate assets. The following shall not be included and shall not be used for recovery in the liquidation. One is the assets owned by a third party, which are in possession of the corporate debtor, including assets held in trust for any third party, bailment contracts, all sums due to any workman or employee from the provident fund, pension fund, or gratuity fund. Now, this aspect is once again very important, as it has also been brought about in the matter of Sundaresh Bhatt versus ABG Shipyard. We'll come to a brief discussion of it in the coming slides. Then further, any other contractual arrangements which do not stipulate transfer of title, but only use of the assets, and such other assets which may be notified by the central government in consultation with any financial sector regulator. Now, this is why this issue to understand the liquidation estate is important, is because while we are building up the assets to be sold out and the assets to be transferred and assets which are part of balance sheet, we also need to understand what all we can include and what all we can exclude, so as to come to the distribution mechanism also in as per section 53. Further, the assets in security collateral held by financial services providers subject to netting and set off in multilateral trading or clearing transactions. Personal assets of any shareholder or partner of a CD as may be provided. Such assets are not held on account of avoidance transactions that may be avoided under this chapter. Assets of any Indian or foreign subsidiary of the CD, or any other assets as may be specified by the board, including assets which could be subject to set off on account of mutual dealings between the CD and any other creditor. Further, there is this regulation 21A, which is talking of the presumption of security interest. It says that a secured creditor shall inform the liquidator of its decision to relinquish its security interest to the liquidation estate or realize its security interest, as the case may be, in Form C or Form D of Schedule 2, provided that where a secured creditor does not intimate its decision within 30 days from the liquidation commencement date, the assets covered under the security interest shall be presumed to be part of the liquidation estate. Where a secured creditor proceeds to realize its security interest, it shall pay as much towards the amount payable under Clause A and Subclause 1 of Clause B of Subsection 1 of Section 53 as it would have shared in case it had relinquished the security interest. We come to the options of secured creditors in liquidation proceedings. The options that the secured creditors have in liquidation proceedings are relinquish its interest, security interest to the liquidation estate, and receive proceeds from the sale of assets by the liquidator in the manner as specified in Section 53, or realize its security interest under Section 52(1)(b), or realize its security interest under SURFACI or Recovery of Debts and Bankruptcy Act 1993. Now, to a further complete understanding why we are discussing this whole thing is because the whole distribution and the waterfall mechanism will be put into place, or rather its analysis would depend upon what is going to be the rights subsisting between various stakeholders, most of it comprising of the secured creditors and the inter se creditors arrangement within the secured creditors. So for this purpose, we need to understand further sections 30, which talks of the submission of the resolution plan. Now, while we discuss this section 30, we will only discuss the issues which are right now related to the waterfall mechanism here. Now, as per section 31, a resolution applicant may submit a resolution plan along with an affidavit stating that he's eligible under section 29A to the RP prepared on the basis of the information memorandum. The resolution professional shall examine each resolution plan received by him to confirm that each resolution plan provides for the payment of the IRP costs in a manner specified by the board in priority to the payments of other debts of the CD, or provides for the payment of debts of operational creditors as may be specified by the board, which shall not be less than the amount to be paid to such creditors in the event of a liquidation of the corporate debtor under section 53, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of section 53. Now, while we are talking about the resolution plan, again, the section 53 is coming into play for the amounts which would have been due to the secured creditors, as well as the amounts which would have been due to the operational creditors. So the amount that would have been paid to them if the amount distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of section 53. So in case there are operational creditors, then either the minimum that they must receive is the amount which would have been really distributable to them as per section 53, whichever is higher, and provides for the payment of debts of financial creditors who do not vote in favor of the resolution plan in such manner as may be specified by the board, which shall not be less than the amount to be paid to such creditors in accordance with subsection 1 of section 53 in the event of a liquidation of the CD. For the removal of doubts, it is clarified that a distribution in accordance with provisions of this clause shall be fair and equitable to such creditors. We'll come to the issue which is important at hand as far as this is concerned, where a resolution plan has not been approved or rejected by the adjudicating authority, where an appeal has been preferred under Section 61 or Section 62, or such an appeal is not time barred under any provision of law for the time being in force, or where a legal proceeding has been initiated in any court against the decision of the adjudicating authority in respect of a resolution plan. Further, the resolution plan has to have all these requirements. We go to the next slide, which says that this section, the resolution professional shall present to the Committee of Creditors for its approval such resolution plans which confirm the conditions referred to in subsection 2. The Committee of Creditors may approve a resolution plan by a vote of not less than 66% of voting share of the financial creditors after considering its feasibility and viability, the manner of distribution proposed, which may take into account the order of priority amongst creditors as laid down in subsection 1 of section 53, including the priority and value of the security interest of a secured creditor and such other requirements as may be specified by the board. We'll just briefly discuss this issue before I go to the further slides. Now, section 53 gives a ranking wherein the CIRP costs and the liquidation costs, that is number one. And number two, it talks about the secured creditors falling pari passu along with the workman's dues for 24 months preceding the liquidation commencement date. And further, it gives an explanation which says that the inter se or rather any other arrangement, any contractual arrangement would not be given any priority. Now, the question which comes in, the most important question which comes in is that while we talk of the inter se creditors arrangement, the security interest of the secured creditor has not been really brought about anywhere under section 53. The code has been silent on it, and our major issue which comes while the distribution is being done under section 53 is that how the payments to a secured creditor must be made. Whether the secured creditors should be paid as per the security interest of each secured creditor, or they all would rank equally once they relinquish their claims to their to the assets and such. And then the distribution should be made as per their voting rights or as per their admitting claims, which are dependent once again upon the voting rights, which are dependent upon the admitted claims. The reference to this has been made in this section 30, subsection 4. While it says that the Committee of Creditors may approve a resolution plan with not less than 66%, after considering its feasibility and viability, the manner of distribution proposed, which may take into account the order of priority amongst the creditors as laid down in section 1, including the priority and value of the security interest of a secured creditor, and such other requirements as may be specified by the board. Now, there have been minimal references to this issue in the code. And then further, there is the ILC report, we'll just come to it, which talks of the security interest of a secured creditor. While we are talking, there has been a case also, we'll just come to it also, wherein the NCLT, Honorable NCLT had given a decision saying that the distribution to the secured creditors should be made as per the security interest of each secured creditor. This is Technology Board of India versus Anil Goyal. And this was taken up with NCLAT. It was filed, an appeal was filed against this to Honorable NCLAT, wherein the NCLAT had held that the inter se arrangement, or rather the inter se priority, would not be given any credence, and that all the distribution should be made as per the admitted claims and the ratio that each is having, each creditor is having. The same matter has now further gone to Supreme Court and is still under still sub judice. No decision has been taken on it. We have to understand the pros and cons of this issue as far as the waterfall mechanism is concerned, and we are trying to look at it, which sections and which provisions govern this particular issue of the inter se creditors priority. So one of them is this section 30, subsection 4. Further, we can move on to the next issue. This is all about the resolution plan. Talking about the section 29A, where the resolution applicant shall be allowed by this committee of creditors not exceeding 30 days to make payment of overdue amounts in accordance with provision to clause C of section 29A. This is again in reference to the resolution plan, which does not have much of this with section 53. So we'll come to now the Insolvency Law Committee report, which is clause 21, which is once again talking of this issue of the treatment of subordination agreements within the liquidation waterfall. We'll just come to a brief discussion of it. Section 53 of the code provides the order of priority to be followed for payment of dues pursuant to liquidation of a corporate debtor under the code. It was stated to the committee that it was not clear whether the inter-creditor or subordination agreements entered into between creditors will be respected in the payment waterfall provided in section 53 of the code in the event a secured creditor relinquishes its security and chooses to receive proceeds from sale of assets under liquidation. This is section 53(1)(b). It states, like the following debts which rank equally shall between and among the following: worksman dues for the period of 24 months preceding the LCD, and the debts owed to a secured creditor in the event such secured creditor has relinquished security in the manner set out in section 52. However, it was stated to the committee that in practice, subordination agreements inter se creditors were respected in winding up proceedings. This was also stated to be the position in other developed countries. Specifically, it was also brought to the committee's attention that in USA, the bankruptcy code states that in case of liquidation, a subordination agreement is enforceable in a case under this title to the same extent that such agreement is only to the extent to the same extent that such agreement is. However, it was stated to the committee that in practice, subordination agreements inter se creditors were respected in, I'm sorry, I think this is just double. Yeah, such agreement is enforceable under the applicable non-bankruptcy law. It was held in this case that only because of the dues of the workmen and dues and debts due to the secured creditors are treated pari passu with each other, and the same by itself, in our considered view, would not lead to the conclusion that the concept of inter se priorities amongst the secured creditors had thereby been intended to be given a total go-by. This is the certain other relevant principles that emerge from this case are: right to property was a constitutional right, and right to recover money lent by enforcing a mortgage was also a right to enforce an interest in the property. Had the parliament intended to take away such a valuable right of the first charge holder, there was no reason for it to not say so explicitly. Now, the Insolvency Law Committee also has considered it that in case the in case the code or the parliament would have considered to overlook the aspect of the security interest of each creditor, they would have actually done it by explicitly mentioning that aspect. The fact that it has been not mentioned explicitly, and we are taking, we are also trying to look at the other codes, also in the Transfer of Property Act, and also a constitutional right which says that right to recover money lent by enforcing a mortgage was also a right to enforce an interest in the property. Now, since it has not been mentioned so explicitly, it is assumed that this right was not allowed to be taken away from the first charge holder. Further, the Insolvency Law Committee states that Section 48 of the Transfer of Property Act clearly provides that the claim of a first charge holder shall prevail over the claim of a second charge holder. Merely because the relevant section did not specifically provide the rights of priorities over the mortgage assets, it would not mean that the provisions of Section 48 of the Transfer of Property Act shall stand obliterated in relation to a company that has undergone liquidation. Deprivation of a legal right existing in favor of a person cannot be presumed in construing a statute, and it is in fact the other way around, and thus a contrary presumption shall have to be raised. Now, this is what has been mentioned by the Insolvency Law Committee. Companies Act may be a special statute, but if the special statute does not contain any provisions dealing with contractual and other statutory rights between different secured creditors, the specific provisions contained in the general statute shall prevail. Now, this is very important, that if there are no specific provisions contained in the otherwise mentioned, dealing with the contractual and other statutory rights between different secured creditors, the general statute shall prevail. Further, we go to understanding that section 529(1)(c), it used the phrase the respective rights of secured and unsecured creditors. This was to be interpreted as rights of secured creditors vis-a-vis unsecured creditors. It does not envisage respective rights among secured creditors. So, the committee felt that the principles stated above that emerged from the ICICI case are also applicable to the issue at hand under section 53 of the code. Moreover, although this was a case where creditors had not relinquished their security, the principles hold good under the code even when creditors have relinquished their security, as the code, unlike the CA 1956, expressly recognizes secured creditors who have relinquished their security as a separate category in section 53(1)(b)(2) and distinguishes them from unsecured creditors. The code, in a bid to encourage relinquishment, also specifically places secured creditors who have relinquished security higher than the unsecured creditors. Lastly, it was also deliberated whether inter-creditor agreements, if not disregarded for the liquidation waterfall in section 53 of the code, may result in secured creditors, especially those holding a first charge to the preferred liquidation over resolution. It was suggested to the committee to clarify whether inter-creditor agreements hold good for the distribution of proceeds on liquidation under section 53 in order to promote resolution over liquidation. The committee, as discussed in the context of the ICICI case above, noted that it may not be prudent to take away a valuable property right vested with the creditors. The committee felt that generally all secured financial creditors, whether first charge or secondary charge holders, are sophisticated entities which grant loans after exercising due diligence and are presumed to be able to evaluate their interests and risks sufficiently. We'll just try and understand what the Insolvency Law Committee report is trying to say. What is coming out from this whole discussion, as mentioned in the Insolvency Law Committee report, is that in case the inter se creditors arrangement vis-a-vis the security interests created with each creditor is overlooked, the whole financial market may undergo chaos. Because we all understand, as it is mentioned here also, that it says that generally that all these creditors are sophisticated entities which grant loans after exercising due diligence and are presumed to be able to evaluate their risks and interests efficiently. Now, in case the creditors would have thought it appropriate to give the loans or grant the loans without a security interest, they would do it like that only. They have done their due diligence and they would give the loans based upon the security interest or without it after doing their due diligence. So in case this whole aspect of looking at the rights of the secured creditors as far as their secured interest is concerned is overlooked, the whole market would undergo a chaos and the creditors would not be able to envisage whether they would be able to, the loans, the justice would be able to be given to them if the corporate debtor goes under liquidation. So considering that even the Insolvency Law Committee has upheld this inter-creditor agreements as far as the security interest of each is concerned. Moreover, this may negatively, see, this is what the Insolvency Law Committee report is saying, this may negatively impact the credit market and discourage banks and other financial creditors to grant big loans, which are more often than not granted against property or other valuable collateral, as they shall have no protection in case the corporate debtor becomes insolvent. Accordingly, the committee disregarded this suggestion. To conclude, the committee was of the opinion that it is sufficiently clear from a plain reading of section 53(1)(b) that it intended to rank workmen's dues equally with debts owed to secured creditors who have relinquished their security. Section 53(1)(b) does not talk about priority inter se secured creditors. Thus, valid inter-creditor subordination agreements would continue to govern their relationship. I'll take a small example. If there are 5 secured creditors and 2 of them have their security interest, which is at a much higher level as compared to the other 3 who have at a much lower level, in case they are just given the in case the distribution in these as per section 53 is made as per the admitted claims only, then there would be the security interest aspect would not really have any meaning in the long run, and anybody who would be granting loan would not be able to assess, to what extent they should grant a loan, and whether in future the security interest that is being created and the mortgage which is being offered by the CD, whether they would be able to make use of it, or whether they would be able to really at the time of, in case the corporate debtor goes into liquidation, whether the justice would be done to them. So this is how the committee concluded it, that since section 53(1)(b) does not talk about the priority inter se secured creditors, therefore the subordination agreements would continue to govern their relationship. Further, subsection 2 of section 53 must also be interpreted accordingly. For instance, applying section 53(2) in the context of section 53(1)(b), any agreements between workmen and secured creditors which disrupts their pari passu rights will be disregarded by the liquidator. Now, this is referring to the section 53(1). This is referring to section 53(2), where it is said that all contractual arrangements which disrupts their pari passu rights will be disregarded. So this is only in case the workman's dues and the secured security and the dues for the secured creditors, if any relationship between them or any ratio between them is disturbed because of any agreements, that should be disregarded by the liquidator, but it does not mention about the inter-creditor relationship as far as the security interest is concerned. However, agreements inter se secured creditors do not disturb the equal ranking sought to be provided by section 53(1)(b) and therefore do not fall within the ambit of section 53(2). The committee felt that there was no requirement for an amendment to the code required, since a plain reading of section 53 was sufficient to establish that valid inter-creditor and subordination provisions are required to be respected in the liquidation waterfall under section 53 of the code. The appellate authority, in its recent landmark judgment in the case of Technology Development Board versus Anil Goyal, liquidator of Gujarat Oleo Chemical Limited, made it specifically held that whether the secured creditor holds a first charge or second charge is material only if the secured creditor elects to realize its security interest. However, once a secured creditor opts to relinquish its security interest, the distribution of assets would be governed by section 53(1)(b)(2), which states that all secured creditors who have renounced security interests rank equally. Now, this is the judgment given by Honorable NCLAT, wherein the inter se security interests have been overlooked. However, now this case is pending with the Honorable Supreme Court, and its decision is still about to come. I'm sure the things would fall in place once we have a judgment from the Honorable Supreme Court. Do we have any questions still here? Anybody would like to say anything, or any observations, any questions? Okay, we'll just proceed. Further, we go to the statutory provisions. The statutory provision which sets out the order of priority for the distribution of sale proceeds from the sale of liquidation assets is categorically mentioned under Section 53 of the IBC Code. According to Section 53(1)(b), the following debts will be ranked equally between and among them: workmen's dues for a period of 24 months and debts owed to a secured creditor in the event such secured creditor has relinquished security. According to Section 53(2) of the Code, the liquidator will overlook any contractual arrangements between receivers under subsection 1 with equal ranking if they disturb the sequence of priority under subsection 1. This is just a summarization of what we've just discussed in detail. Now, if we now go into the detail of each clause of Section 53, a secured creditor is one in whose favor a security interest has been created by the CD. Section 52 of the Code provides the secured creditors with two options. First is either to realize its security interest or give away its security interest to the liquidation estate. It is the duty of each secured creditor to communicate to the liquidator about his decision to either relinquish his security interest or to realize its security interest. If the secured creditor fails to inform the liquidator of its intention within 30 days from the commencement of the liquidation process, the security interest held by such secured creditor is deemed to be relinquished. In case a secured creditor chooses to relinquish its security interest, then it has to stake its claim to the liquidation estate. We come to a brief discussion of the distributive justice under this code. Different stages under the code which talk about the insolvency resolution process. The resolution plan must be taken into consideration, priority laid down under Section 53. This is Section 32(b) and Section 30 subsection 4, which we have just discussed, that the resolution plan must also consider priority laid down under Section 53. Then the haircut may be faced by creditors. However, priority must be maintained by the resolution plan. This is also amendment introduced on the basis of Honorable Supreme Court in SR Steel versus Satish Kumar Gupta and others. The crux of the liquidation process is distribution on the basis of priorities. Deficit in realization makes it necessary to have priorities ascertained with clarity to ensure distributive justice. So here, why we are talking about is to ensuring distributive justice. It is very important that the priorities are taken into consideration. However, any further arrangements to reallocate the funds should not be accepted by the liquidator, and it is not allowed under the code under any circumstances. As far as voluntary liquidation is concerned, in case the assets are greater than liabilities, all creditors shall be paid in full. However, by virtue of priority based on sequence, Section 53 must be followed. Excuse me. Now, in case of liquidation as a going concern also, there are different forms of going concern transfers, which could be transfer of the corporate debtor or the transfer of the business of the corporate debtor. As far as the scheme of arrangement under Section 230 as a part of liquidation process is concerned, if the scheme of arrangement is sanctioned by the shareholders, creditors and the NCLT, the matter comes out of liquidation and it becomes a debtor-creditor contract. Further, is it relevant in case of winding up under the Companies Act? Priorities are there under the Companies Act, though the priorities are a shade different. So in Companies Act, it is a little different. Relevance of priority in resolution plans. Enshrined in Section 32, subsection B, OCs must receive a minimum of the liquidation value or amount under resolution plan if distributed as per Section 53, whichever is higher. Dissenting financial creditors under Section 32 must also be paid minimum liquidation value. Section 30, subsection 4 provides that COC may approve a resolution plan after considering its feasibility and viability, which may take into account the order of priority amongst the creditors under Section 53, subsection 1. Also upheld by Honorable SC in SR Steel versus Satish Kumar Gupta, what is left to the majority decision of the COC is the feasibility and viability of a resolution plan, which obviously takes into account all aspects of the plan, including the manner of distribution of funds among the various classes of stakeholders. I'm sorry for the little disturbance today because of my very bad throat and further provision to section 30 subsection 2 says that for removal of doubt, it is hereby clarified that a distribution in accordance with the provisions of this clause shall be fair and equitable to such creditors. Why we are going to all these sections is to explain that how the code has looked at the angle of distribution of proceeds, whether it is a resolution plan or if it is a distribution under section 53 pursuant to a liquidation of a CD. Under all the cases, the code has referred to certain binding provisions only according to which the distributions should be made under whether it is a resolution plan under section 30 or it is a liquidation distribution under section 53. Can Regulation 38(3)(b) requires the resolution plan to be feasible and viable, and section 34 of the code includes taking into account order of distribution while determining priority. Horizontal and vertical equity in resolution plans. Horizontal equity is all creditors of equal ranking must be placed in the same ranking. Examples of fair and equitable distribution plans. A secured creditor cannot become unsecured creditor or vice versa. A senior creditor cannot become junior creditor or vice versa. Rights against third parties cannot be obliterated, which is very clear. The horizontal equity is there, that the creditors who are falling in one ranking equally must be placed in the same ranking, and only
Madam, except when secured creditor foregoes his security, then for his balance portion of realization, he will become unsecured
yes,
creditor.
absolutely. That we'll come to it. That will fall under 53(1)(e). The part which is not paid, one is of course the who has not relinquished his security. He will not fall under. He will no more be a part of the 53(1)(a), and his ranking will go much lower. Apart from that, all the creditors who are falling in the of equal ranking, they have to be placed in the same ranking. Further, the treatment of the creditors equal versus equitable, whether prioritization disturbs or distorts equitability. Code posits a fair and equitable treatment of creditors does not mean that all creditors can be treated equally. Further, we have examples in Swiss Ribbons versus Union of India and SR Steel India versus Satish Kumar Gupta. As per the principles for effective insolvency and debtor creditor regimes by World Bank, insolvency law systems should provide for equitable treatment of similarly situated creditors. Now, this prioritization also encourages equitability. This unique trial legislative guide states that the objective of equitable treatment is based on the notion that in collective proceedings, creditors with similar legal rights should be treated fairly, receiving a distribution on their claim in accordance with their relative ranking and interests. Further, the American jurisprudence also brings about the bankruptcy system is designed to distribute an estate as equally as possible among similarly situated creditors. Thus, creditors of equal status must be treated equally and equitably. So our entire waterfall mechanism is trying to bring about the issue of the security interests and section 53, vis-a-vis section 53, and that the rankings as given as per section 53 must be respected completely and absolutely, and there can be no exception to that.
Madam, just one small doubt.
Yeah.
Where does this secured creditor related party, where would they go and stand? Though they are like a related party, they are a secured lender. Where do they go and sit, madam, on the water flow?
No, the secured creditor, in as far as their security is concerned, they will fall under the same ranking. It is not
Even
that
related party, but they cannot only participate in the voting.
They cannot participate in the voting.
Or rest all they will stand in the same pattern.
Yes, they will all stand in the same pattern. In case they have a security interest, their right would be there on that security interest. But as far as the voting rights are concerned, they would not have any voting rights.
Fair enough.
Yeah. The waterfall mechanism priorities under section 53(1) of IBC. Now, this is once again we come to the priority as given under section 53(1), insolvency resolution process costs and liquidation costs in full. Now we come to a now that we've done so much of discussion, we once again come to it that these two costs have to be paid in full, and then there has to be a ranking, and then the pari passu between workmen's dues for 24 months prior to LCD and secured creditors. Then employees' dues other than workmen for 12 months prior to LCD. Then financial debts owed to unsecured creditors. Then statutory dues for 24 months prior to LCD and remaining amount towards secured creditors. Now, in case the secured creditors have a certain amount which is left over after distribution as per the security interest, then that would fall under this, which is remaining amount towards secured creditors. Further, the remaining debts and dues, preference shares, and then equity shareholders. The priorities under the Companies Act, pari passu payments. Now, the Companies Act had also given up this mechanism for distribution, which was pari passu payments to the workmen's dues, debts due to secured creditors. All revenues, taxes, cesses, and rates due from the company to the central or state government or to a local authority. All wages or salaries in respect of services rendered to the company and due for a period not exceeding 4 months within the 12 months prior to the commencement of liquidation. All accrued holiday remuneration becoming payable to any employee. All amounts due in respect of contributions payable during the 12 months next before the relevant date by the company as the employer of any person under the ESI Act 1948. Except in case of voluntary liquidation or arrangement, all amounts due in respect of contributions payable by the company as the employer of any persons under the Workmen's Compensation Act 1923. Except in case of voluntary liquidation or arrangement, all sums due to any employee from a provident fund, a pension fund, a gratuity fund, or any other fund for the welfare of the employees. The expenses of any investigation held in pursuance of section 235 or 237, insofar as they are payable by the company. Now, if you look at the Companies Act also, they had given a sufficiently fair provision as far as the payments or as far as the distribution in times of liquidation was there. The workmen's dues were respected, the secured interests, the secured creditors' interests were respected equally. And the state governments and the central governments, taxes, cesses, etc. also were there. But then section 53 has come up as even, a more refined section as far as the IBC is concerned. Where a lot of clarity has been given and a very concrete mechanism has been given as far as the distribution of proceeds is concerned. But of course, the Companies Act has the basis based on which this whole thing has been devised. The Companies Act 2013 is also giving the same provisions as far as similar provisions as far as the distribution is concerned. So the historical perspective has always been for a fair and equitable distribution to all the stakeholders. The pari passu payments to a workman's dues, debts due to secured creditors, so much of the debts due to such secured creditor as could not be realized by him, or the amount of workman's portion in a security, whichever is less. All revenues, taxes, cesses, and rates due from the company to the central government or a state government or to a local authority up to 12 months prior to relevant date. All wages or salaries due for a period not exceeding 4 months within the 12 months immediately before the relevant date. All accrued holiday remuneration becoming payable to any employee. So this was as per the Companies Act 2013. All amounts due in respect of contributions payable during the 12 months next before the relevant date by the company as the employer of any persons under the ESI Act, like we had just discussed, except in the case of voluntary liquidation and arraignment, all amounts due in respect of contributions payable by the company as the employer of any persons under the Workmen's Compensation Act 1923. Except in the case of voluntary liquidation or arrangement, all sums due to any employee from the Provident Fund, the Pension Fund, the Gratuity Fund, or any other fund for the welfare of the employees maintained by the company. The expenses of any investigation held in pursuance of sections 213 and 216 insofar as they are payable by the company. Once again, if we come to the contours of the liquidation estate, what is to be distributed is the liquidation estate itself. Hence, it is important to understand what will not be part of liquidation estate. All these monies are not impressed with the color of liquidation estate. What is falling outside the liquidation, the domain of the liquidator is money held in trust, for example, security deposit held by the company. If against specific property or obligation, it is typically not a part of the funds of the company. The usual rule is setting aside of a fund for the payment to creditors creates a trust. We have an example in Baroda spinning and weaving mills. Further, the bailment of assets, amount in Provident Fund, Pension Fund, and Gratuity Fund. These are some of the further questions as far as the funds are concerned. So in case there is any fund, which is a provident fund or a pension fund or a gratuity fund, then that will only be distributable to the workers. In case there is no fund, then again the waterfall mechanism will prevail, which is the liquidation estate will be distributed as per section 53(1)(a) and A, B, C, D, E, F, G. And then in case there is any fund, then it will be only distributable to that particular workers. Priorities under section 53(1) of IBC clause A. Now, what constitutes CIRP cost? If we go into further the details of how the distribution should be made and to what all areas the distributions can be made, we come to 53(1)(a). CIRP costs includes the amount due to suppliers of essential goods and services, fee payable to AR of class of creditors, including the out-of-pocket expenses of RP for discharge of functions, amounts due to persons whose rights are prejudicially affected due to moratorium, expenses incurred on and by the RP, other costs directly related to CIRP and approved by COC. Now, where the expenses incurred towards or by IRP are not ratified by the COC, the applicant must bear the expenses. That is, anything which can form part of the CIRP costs is only after the ratification by the COC. In case there is no ratification by the COC, then it cannot form part of the CIRP costs. Only expenses which are ratified shall form part of CIRP costs. Then the interim financing and cost thereof, as per section 513, not forming part of CIRP costs, any fee or other expense beyond the amount approved by COC. Any expense incurred by a creditor, claimant, resolution applicant, promoter, or member of the board of directors of the CD in relation to the CIRP. Any fee or other expense incurred before the commencement of CIRP or to be incurred after the completion of CIRP. So in case it is any expense which is prior to the commencement of the CIRP or after the completion of the CIRP, that will not form part of the CIRP cost. Or any expense which is done by the creditor, the claimant, resolution applicant, promoter, member of the board of directors of the CD in relation to the CIRP will not form part of the CIRP cost. Further, it is held, in view of the above and for the reasons stated above, it is held that the wages, salaries of the workmen employees of the corporate debtor for the period during CIRP can be included in the CIRP costs, provided it is established and proved that the IRP or the RP manage the operations of the CIRP of the corporate debtor as a going concern during the CIRP, and that the concerned workmen and employees of the CD actually work during the CIRP. Now, this is as per the case of Sundaresh Bhatt versus ABG Shipyard, wherein a further detailing was given as to what will form part of the CIRP costs as far as the workmen dues are concerned. If we go into a further explanation of this, we can come out very clearly. Can we take a 5 minutes break?
Yes,
Somebody,
ma'am.
yeah, we'll just take a 5 minutes break. We'll come back.
Sure, ma'am.
Yeah, thank you.
I wanted to just.
Yeah.
Hello.
Yeah. Yes. I can hear you.
There were breaks in between coming. Is it only in my laptop or connection, or everybody was facing it?
I don't know. Please let me know. Maybe others can.
Writing message also. Okay, so that means my connection is bad. Okay, thank you.
Okay. I hope the others are able to hear and see without any breaks.
Yes, ma'am.
Okay. So we'll just come back after a 5-minute break.
Sure, ma'am.
Yeah. Thank you. So I think we can start.
Sure, ma'am.
Yeah, okay.
Yeah, sure.
So while we were just discussing this in view of the above and for the reasons stated above, it is held as under that the wages and salaries of the workmen employees of the corporate debtor for the period during CIRP can be included in the CIRP costs, provided it is established and proved that the IRP or the RP managed and the operations of the CD as a going concern during the CIRP, and that the concerned workmen or employees of the CD actually worked during the CIRP, and in such an eventuality, the wages and salaries of those workmen or employees who actually worked during the CIRP period when the resolution professional managed the operations of the CD as a going concern shall be paid, treating it and or considering it as part of the CIRP costs, and the same shall be payable in full. First, as per section 53(1)(a) of the IB code. I'll go slightly into the discussion of the case of Sundaresh Bhatt versus ABG Shipyard, wherein the decision was taken while we are calculating the CIRP costs, because the section 53(1)(a) very clearly says the CIRP costs and the liquidation costs paid in full. Now, while we are discussing about the CIRP costs, whether the cost payable to the workmen will form part of the CIRP costs and would be paid in full, or they will fall under section 53(1)(b) and C. For this, the case the Honorable Supreme Court has held in Sundaresh Bhatt versus ABG Shipyard that the wages and salaries of the workmen or the employees who have actually contributed towards working in the while the operations were kept as a going concern by the RP, as a going concern, only that aspect, only that particular part of the workmen and salaries of the workmen will form part of this section 53(1)(a) and will be paid in full, as they would be included and be part of the CIRP costs. Any workmen who have not actually worked and the company was not kept as a going concern during CIRP, under those circumstances, the wages and salaries of the workmen and employees will form part of 53(1)(b) and C, and they will not be paid in full. They will once again rank pari passu along with the secured creditors. So we come to the final the verdict given by the Honorable Supreme Court that only if it is proved that it is the company has been kept a going concern and that the specific workers have actually contributed while it was a going concern, they will form part of 53(1)(a) of the IB code. Considering section 36(4) of the IB code, and when the Provident Fund, Gratuity Fund, and Pension Fund are kept out of the liquidation estate assets, the share of the workman dues shall be kept outside the liquidation process, and the concerned workmen or employees shall have to be paid the same amount out of such Provident Fund, Gratuity Fund, and Pension Fund, if any available, and the liquidator shall not have any claim over such funds. This is also the part of the judgment which was delivered by Honorable Supreme Court in the case of Sundaresh Bhatt versus ABG Shipyard, wherein it was held that any funds which are available with the corporate debtor, which include the Provident Fund, Gratuity Fund, and Pension Fund, shall not form part of the liquidation estate, and the liquidator shall have no claim over such funds, and such funds would be kept completely and categorically for only the workmen and employees, and only this amount can be payable to the workmen and employees. Apart from that, any other dues of the workmen and employee shall be governed by section 53(1)(b) and C. We come to critical supplies versus essential goods, which forms part of CIRP cost. The essential supplies are which forms part of the CIRP cost under regulation 31A of CIRP regulation. Now, this is again CIRP cost which can be paid in full, which is as per section 53(1)(a). The essential goods and services shall mean electricity, water, telecommunication services, and information technology services, to the extent these are not a direct input to the output produced or supplied by the corporate debtor. Now, this is an important line to the extent that these are not a direct input to the output produced or supplied by the corporate debtor. If we talk of the electricity produced, or rather, if we talk of the electricity bill of a company of a corporate debtor, that will form part of the essential goods and services. But in case the company is a power company and it is into actually production of electricity, in that case, any input or output which is utilized by the corporate debtor is, and it is a direct input or output, input to the output, and is a part of the raw material, that will not be an essential service, that will be forming part of as the raw material. Further, the critical supplies, which is not an explicit part of the IRP cost, section 14(2)(a) inserted by amendment of 2020, critical to protect and preserve the value of the corporate debtor and manage the operations of such corporate debtor as a going concern, as what the IRP or the RP considers to be critical. The supply of such goods or services shall not be terminated, suspended, or interrupted during the period of moratorium, except where such corporate debtor has not paid dues arising from such supply during the moratorium period or in such circumstances as may be specified. Now, this does not mean that everybody will just have to continue with the essential or critical services. The corporate debtor must also pay the dues relevant to that particular period. The dues which are relevant, which are rather prior to the insolvency commencement date, can form part, they can put up their claims for those dues. But as far as the dues for the CIRP period are concerned, they need to be paid by the IRP or the RP, as the case may be, and they will form part of the CIRP cost. Not now, in case any electricity bill is pending which is prior to the CIRP commencement date, that can only a claim can be filed for the same. But then if it is for the period of the CIRP time, then it must be paid, and then it cannot be disconnected. It will be under the moratorium. Then past dues till insolvency commencement date, they can also be paid as a part of the resolution plan in case it is going in for a resolution. Priorities under section 53(1) of IBC clause A. This is again the same thing, the liquidation costs. Up till now we have discussed the CIRP cost. Now we come to the liquidation costs. If the institute will permit me, I have with me Mr. Chandan Bhugra for me, since I'm having a very bad throat. Yeah.
Sure, ma'am. No issue.
Yeah, Mr. Chandan, are you there?
Yes, I am.
Yeah, just please can you read this part, please? Thank you.
So the priorities under 53 section A, section 1 of IBC clause A, CIRP and liquidation cost. The liquidation cost under regulation 2E and A include the fee of the liquidator, the remuneration paid by the liquidator for professional services, the costs which are incurred for verification of the claim, for protection of assets of the CD, for carrying on the CD as going concern, interest on the interim finance. All these costs are part of the priorities under 53A, 53(1), sorry. Next slide. So the fee of the liquidator in terms of regulation 4 includes can either be percentage based or can be decided as by the C of C. Interest on interim finance for the period lower of either 12 months or LCD pay till repayment of the interim finance. And contribution under regulation 2A of liquidation regulations, read with regulation 39B of CIRP regulations, can include entitled to interest at bank rate or any cost incurred by the liquidator in relation to the scheme of compromise or arrangement, which does not form the part of the liquidation cost, shall be paid by the applicant.
Thank you. Thank you. So I'll continue. Now this is the liquidation costs which we are talking about here. This will include all these costs, and also once again the costs which are mentioned here, which is the fee of the liquidator and the interest on interim finance, which is either 12 months or till the liquidation commencement date. Then the contribution under regulation 2A, which includes any cost incurred by the liquidator in relation to a scheme of compromise or arrangement, does not form part of the liquidation cost, shall be paid by the applicant. I'm sure we all are aware of this particular provision, which says that during the time of the liquidation, during the time of a scheme of compromise or arrangement, that particular cost will not be paid by the liquidator and shall not form part of the liquidator's liquidation cost, and that needs to be paid by the applicant, who could be the promoter himself, and if he is 29A compliant, or could be any other person who is coming as a part of scheme of compromise and arrangement to buy the company. Now we come to the priorities under section 53(1) of IBC clause B, secured creditors and workmen dues. Now this is what we've already discussed: pari passu distribution towards workmen dues and secured creditors, workmen dues towards dues up to 24 months prior to LCD, and secured creditors where the security interest is relinquished. Workmen as defined under the Industrial Disputes Act, meaning of workmen dues as per section 326 of the Companies Act, as per which workmen dues mean aggregate of all salary or wages, accrued holiday remuneration, all amount due in respect of any compensation or liability for compensation in respect of death or disablement of any workman. Sums due towards PF, pension and gratuity outside the scope of section 53, read with section 36(4)(a)(3). Now this is which are falling outside the scope of section 53. Now PF, pension and gratuity, which are the funds, in case the funds are available, in that case the funds will be payable only to these workmen. In case the funds are not available, then as per section 53 only. We have this example of SBI versus Moser Baer Karamchari Union, wherein secured creditors' claim is covered to the extent of value of security and not the total sum due, and the recommendations of the second ILC report. We have just discussed the ILC report in detail. So also the aspect of the workmen's dues that we have just covered as per the judgment delivered by Honorable Supreme Court in the Sundaresh Bhatt versus ABG Shipyard. Chandan, can I request you further once more? Thank you.
Sure. Wide coverage of the expression, i.e. wages. There have been lots of rulings defining what all is included in wages. Rulings under the winding up regime of the 1956 Act should all remain relevant. This may include the following. The following have been included in definition of wages, which includes dearness allowance, bonus, unavailed leave. Compensation for termination is clearly covered by explanation B below section 326(2) of the Companies Act. The things which are not included under the wages are the ex gratia payment. Next slide. The secured creditors are evidently the largest claimants in resolution liquidation proceedings. The points which are important to understand here are: is the person a creditor or a secured creditor? What is defined under section 330 and section 331 seem generally broad. An example here is an owner of an asset taken on financial lease is not a creditor. Then the question here is the security interest registered? Under section 77(3) of the Companies Act, unregistered charges not to be taken cognizance of. Has the creditor relinquished security interest, or are deeming provisions applicable?
Thank you. Thank you. I'll continue. So determining the security interest, ascertainable assets or unascertainable assets. We will just come to a discussion on this. Is the security interest registered? We'll just discuss it a little in detail. Determining the security interest, ascertainable assets or unascertainable assets, determining the ranking. The following are not security interests: a mere obligation to pay not being an obligation attached to property, a negative lien or negative pledge, a covenant requiring maintenance of asset, cover, etc. may be a financial covenant, but not a security interest. Also, it is important to note that in section 53(1)(b), it is important to define secured creditor and not financial creditor. There may be secured creditor who is not a financial creditor, partly secured creditor or fully secured creditor. Now, this is very important. We need to understand the differences. It is not important that a financial creditor may essentially be a secured creditor, or it is not it is not important that a secured creditor may essentially be a financial creditor. Even a non-financial creditor can be a secured creditor. So we need to look into the security interests of each creditor before the distribution chart, or rather the distribution details, are prepared. This is very important. Secured creditors and the value of the security interest. Second ILC report, para 7.1 to 7.4, has an important discussion on this issue. Repayment to secured creditors covers value of security interest relinquished. This provision intends to replicate the benefits of security even where it has been relinquished. That's very important. Provision intends to replicate the benefits of security even where it has been relinquished. However, anyhow, they will only have a priority for the amount of security interest, not the entire sum due. So as it has been brought about that in certain, even about by Honorable NCLAT in this Technology Development Board of India versus Anil Goyal, that the security interest would not have any bearing while the distribution is being done, and it has been now the order has been stayed by the Honorable Supreme Court, and the matter is sub judice. Now, the issue which is brought about by the issue at hand has been clarified in the ILC report, where it says that the benefits of security has to be there even when it has been relinquished. However, it will only be till the amount of the security interest and not the entire sum due. That means if there is a total admitted claim of about 100 crores, and then the security interest is only the original security interest is only 50 crores, then the priority will only be till the security interest, not the entire sum due. So secured creditor would be considered only till the extent of security. Therefore, priority of repayment over their entire debt, regardless of the extent of the security interest, is not the intent. So it's very clear. The intent is to protect the security interest, and not that if one creditor is a secured creditor, then his entire debt is protected. That is not the case. Similar provisions in section 110(3)(b) and 123(2)(b), subordination agreements within the liquidation waterfall. The first ILC report clarified that valid inter-creditor subordination agreements would continue to govern their relationships. Agreements inter-secured creditors do not disturb the equal ranking sought to be provided by section 53(1)(b), and therefore do not fall within the ambit of section 53(2). Once again, a mention is, it's very important to understand that section 53(2) says that the inter-se creditor arrangement will not be given any priority. Now, it does not say that inter-se secured creditor will not be considered. So in case, like we have just discussed in the earlier slides, in case the intent of the law would have been, it would have actually brought that about explicitly and not left it unattended. However, the ILC report has clarified that the agreements inter-se secured creditors do not disturb the equal ranking as per section 53(1)(b), and therefore they do not fall within the ambit of section 53(2). So we can continue to respect them. Chandan, please, can you just speak? Thank you.
Sure. Priorities under section 53(1) of the IBC clause C and D include: the clause C is the wages and employees' due wages and any unpaid dues owed by employees other than workmen for a period of 12 months preceding the liquidation commencement date. And clause D under the unsecured financial creditors, unsecured financial debts have been placed prior to government dues, which have been ranked first in the priority list under the Companies Act 1956. Next slide. Priorities under 53(1) of IBC clause E states that the statutory dues include dues to the central government, to the state government, and includes the amount to be received on account of the consolidated funds of India. Here, secured creditors mean those who had realized outside of liquidation process.
Thanks, I'll continue. Thank you. So here, when we talk about this particular 53(1) C and D, here we are talking about the wages and salaries due to the employees who are not workmen. And for them, it is a period of 12 months prior to the LCD. And the unsecured financial creditors, whose debts have been placed prior to the government dues, which have been ranked first in the priority list. So unsecured financial creditors are placed prior to the next, that is E, which is the statutory dues, which are the dues to the central government and dues to the state government. So this is the pari passu distribution towards the statutory dues and the remaining sums of the secured creditors. For the statutory dues for a period of 2 years prior to LCD, and for the remaining sums of the secured creditors, where after the realization or relinquishment, part of claim is pending. Chandan, please read the rest.
Sure. Priorities under section 53(1) of IBC clause F, G, and H include, for clause F, the residual dues. These are the debts and dues other than those mentioned in the foregoing clauses. For example, operational debts owed to unsecured creditors may fall in this category. Under clause G, preference shareholders. Preference shareholders by nature receive priority in distribution of dividend and assets in the event of liquidation of companies. And under clause G of equity shareholders, the residual bite of the assets of the corporate debtor shall go to the equity shareholders or partners in case of LLPs. Next slide. You want to complete that?
Yeah, I'll take over. Thank you. Now, decision of the secured creditors, realization versus relinquishment. Now, realization by the secured creditor, which is outside liquidation process as per section 52, and under the liquidation process under section 53. Now, we have already discussed it, that the secured creditor may relinquish his security interest under section 53, and his particular interest would form part of the liquidation estate. Or the secured creditor may choose not to relinquish the security interest, and then it would form part under section 52. This would be realization outside liquidation. Further, the realization outside liquidation process, regulation 21A says, the communication of decision within 30 days of LCD in Form C, operational creditor, or Form D, financial creditors. Step 2 is proportional contribution towards liquidation costs and workmen dues, and then within 90 days of the liquidation commencement date. Step 3 is excess of realized amount over submitted claim to be submitted to the liquidation estate within 180 days of the LCD. If we come to the realization outside the liquidation process, regulation 37 governs it. The secured creditor must intimate the liquidator the realizable price at which he proposes to realize the asset. Within 20 days of such intimation, the liquidator shall, of a person willing to buy the asset before the expiry of 30 days of intimation, and at a higher price than intimated by the secured creditor, then the secured creditor shall sell the asset to such a person and bear the cost incurred by the liquidator for identification of such a person. Further, relinquishment by the secured creditors include encumbered assets which do not form part of the liquidation estate unless security interest is relinquished. Regulation 21A of liquidation regulations requires secured creditors must inform decision on non-relinquishment within 30 days of LCD. Failing such communication, it will be a deemed relinquishment. Asset will form part of the liquidation estate. Where not relinquished, asset must be sold within 180 days of the liquidation commencement date. In case it is not sold, then it will fall back into the liquidation estate. We come to a brief on the general rules of priority. Sorry. This is the fixed versus floating charges. The priority of several specific charges on the same property is determined by the general rules relating to the priority of charges. We can go through the state of Andhra Pradesh versus Raja Ram Janardhan Krishna. Further reference to section 48 of the Transfer of Property Act 1882, where a person purports to create by transfer at different times rights in or over the same immovable property, and such rights. Yeah. Somebody wants to say.
Give para numbers and page numbers so that we can refer to that para number and page number.
You are referring to the Transfer of Property Act or the
first one, the state of Andhra Pradesh versus Raja Ram Janardhana.
Yeah, I'll have to look through that and I'll definitely give it. Yes, I'll look through it and I'll
Thank
do
you.
those the para numbers. Yeah, welcome. Now, where a person purports
Para
to
numbers
create
and page numbers.
para number and page number. Yes, yes. I'll write down and I'll send them to you. Yeah. Where a person purports to create by transfer at different times rights in or over the same immovable property, and such rights cannot all exist to be exercised to their full extent together. Each later created right shall, in the absence of a special contract or reservation binding the earlier transferees, be subject to the rights previously created. Now, this is very important. Since there has been no mention to such things or such issues in the IBC code, we are relying on the other codes which have been there already. Section 48 of the Transfer of Property Act 1882. In case the statute or in case the intent of the Parliament would have been to exclude such provisions, they would have mentioned it explicitly. Since it has not been mentioned, we can refer back to these acts. One of these being Section 48 of the Transfer of Property Act 1882, whereby it is very clearly mentioned that in case on the same immovable property, there are two rights created, then the right created latter in the latter time shall be subject to the right created previously. So such rights cannot all coexist, cannot exist to be exercised in their full extent. So each later created right shall, in the absence of a special, in case there's a special contract, then we would make a reference to the special contract. In case there is no such special contract or reservation binding the earlier transferees, it would be subject to the rights which were previously created. This is the general rules of priority, fixed versus floating charges. Further, Section 70 of the Transfer of Property Act 1882 says, if after the date of a mortgage, any accession is made to the mortgaged property, the mortgagee, in the absence of a contract to the contrary, shall, for the purposes of the security, be entitled to such accession. Now, if there is any accession to the mortgaged property, then the mortgagee, in the absence of, in case there is a contract which is contrary to the provisions here, unless there is such a contract, he will be entitled to such accession or over the property. Fixed charges will always prevail over the floating charges. Where a specific charge is created on immovable property, a floating charge cannot have priority. Also, the specific charge, which is the first in point of time, takes priority over the second. This is again the same case, state of Andhra Pradesh versus Raja Ram Janardhan Krishna. Further, a registered floating charge without a restrictive clause ranks after a prior or subsequent specific charge which is duly registered. In case we have, two charges, one of them is a subsequent specific charge which is registered versus a registered floating charge without a restrictive clause, then the subsequent specific charge will have a priority. We have another case, Hamilton's Windsor Iron Works. Further, in the absence of a stipulation to qualify the elasticity of the floating charge, it leaves the company at liberty to create specific mortgages or charges in priority to itself. In case there is a floating charge, and in the absence of any stipulation to that floating charge, the company is always at a liberty to create any specific charges or mortgages in priority to itself. Now, again, we go back to the same, contention rather, which has been given by the ILC report, wherein, it has been mentioned that the parties, or rather the banks or the companies or whatever organizations are actually lending loans, we consider them to be in a good position, or rather we assume that they have done their bit of the due diligence, and they would extend those loans only after doing their due diligence and taking a calculated, defined decision as to whether they would want to do it based on some security interest or without the security interest. In case they have done it without the security interest, then it is their decision which must be respected. And because of such a decision, the interests created by the other creditors who have a valid security interest should not be overlooked. So that is why, once again, it is said that the absence of a stipulation to qualify the elasticity of the floating charge, it leaves the company at a liberty to create any specific mortgages. So a person who has been a lender has not taken any security interest, then the company will always be at a liberty to create specific mortgages or charges in priority to itself. We come to the general rules of priority for registration. Registered charges depend for their validity on registration, but they take priority from the date of the creation through constructive notice arises from the date of registration, though constructive notice arises from the date of registration. Now, the date of registration is also important. So in case the registration depends on their validity on registration, but the date becomes the constructive notice, may be displaced by an estoppel or some equitable consideration, or when the latter charge is a legal charge without actual or constructive notice or has a better equity. Maybe in some cases, if the latter charge which has been created is a legal charge, then it is displaced by an estoppel or some equitable consideration, then it may have a priority. However, the right which the plaintiff has to enforce its mortgage against the property of the company is dependent. Chandan, can you just speak this slide? Yeah.
Sure. Oh, the right which the plaintiff has to enforce its mortgage against the property of the company is dependent, not only upon the registration, but also on the terms of the mortgage itself, and as per the terms of the right which they had. As such, a second charge does not become a first charge merely because of prior registration. Charge created by the company in favor of the second creditor and registered with the registrar is valid and an exclusive charge in respect of immovable properties of the company, and gets priority and prevails over the unregistered charge in favor of the first creditor. This is explained via the Escorts Finance Limited versus the Fidelity Industries Limited interaction, and that Deepika can talk more about.
Thank you. Thank you. So this is a very important part again, that a second charge does not become a first charge merely because of prior registration. So in case, a second charge was registered, created prior to the first charge, then the second charge would only remain a second charge, irrespective of the timing of its creation, even if it was created, prior to the first charge.
ममता ज्वाइन किया क्या?
So this has been clearly given by this case of Escorts Finance Limited versus Fidelity Industries. Further, we come to the first charge versus the second charge, treatment of inter se classifications. First charge holder has the primary interest, security interest over an asset. Second charge holder over the remaining asset after settling claim of the first charge holder. Rights are sequential and not proportional. This is very important. The rights are sequential and not proportional as far as the first and the second charge is concerned. Section 53(2) of the code states that any contractual arrangements between recipients with equal ranking, if disrupting the order of priority, shall be disregarded by the liquidator. Further, we have a few questions as in, can the first charge and the second charge arrangements and other inter se classifications be ignored? The liquidation proceedings must ensure parity and proportionality. Idea of proportionality is only as far as the claims of similar ranking are concerned. Now, the parity has to be maintained always. That means whatever the charges are there, whatever may be the decisions, whatever may be the charges, or whatever may be the waterfall as per section 53, that must be respected, and the proportionality again has to be taken care of. It is only as far as the similar ranking are concerned. Please excuse me, I have to just Where first charge holder does not relinquish interest, will the second ranking remain? Yes. Where the first charge holder does not relinquish the interest, will the second ranking remain? Yes, it will remain. Even if it is relinquished or it is not relinquished, the charge will remain as it is. We'll come to a little bit of discussion on registered versus the unregistered claims. Whether registered with ROC under the Companies Act, whether registered with CERSEI, and whether registered with information utility. In case a particular charge is registered with all the three, that is under ROC under the Companies Act, registered with CERSEI under the SURFACI Act, and whether registered with the information utility, then all rights are protected under the Companies Act, Insolvency Code, and SURFACI Act. In case there is a particular charge which has been registered under the ROC under the Companies Act and registered with CERSEI under the SURFACI Act, but not registered with the information utility, still all rights are protected under the Companies Act, Insolvency Code, SURFACI Act, though mandatory to furnish financial information to IU. Further, if a particular charge is registered with the ROC under the Companies Act, yes. If not registered with CERSEI and not registered with the information utility, in case the rights are protected under the Companies Act since it is registered, and under the Insolvency Act also it is protected since it is registered with the ROC, but not protected under the SURFACI Act. In case it is not registered with the ROC, but it is registered with CERSEI and registered with the information utility, then cannot claim secured status under the Companies Act or the Insolvency Code. However, it can enforce security interest under SURFACI. Further, in case a particular charge is not registered with the ROC, not registered with CERSEI, but yes, registered with information utility, then it will not be considered as a secured status. It cannot enforce any security. Further, if a particular charge is not registered with any of these, then again, it is the same thing. It is not enforceable. So if we come to a bit of a conclusion that the prevailing approach towards the secured creditors' priority rights established at the time of lending supposedly provides them with a security net in the event that the firm defaults and insolvency procedures are initiated. Even after the IBC was enacted, there is nothing in the IBC that specifically addresses this issue. Furthermore, Section 53(2) of the IBC only prohibits agreements that disrupt the waterfall mechanism's sequence of precedence. The problem of priority of inter se secured creditors who have renounced their security interests is left unanswered. As a result, it is clear that there is still lacking legal certainty on this topic. We all understand this very clearly, since the case of Technology Board of India versus Anil Goel, this particular case, since it had the Honorable NCLT had upheld the decision based upon the ILC report, and the secured creditors and their secured rankings and their inter se security interests were protected. However, the Honorable NCLAT gave a decision that the inter se security interest would not be given any priority. The case again has gone to Honorable Supreme Court, and a stay has been granted on the order given by Honorable NCLAT. So the matter is still sub judice, and since there is not much clarity, we have taken such a long discussion on the references made to this issue under the clauses of the ILC report as well as under the clauses of the IBC code, especially sections 30 subsection 4, which clearly says that even under a resolution plan, when the distribution will be made to all the stakeholders, it will consider the security interests. So a reference has completely been made, and we also come to a conclusion that since it has been mentioned in many such cases and many different statutes also, that in case a specific thing which has been laid in the earlier statutes needs to be excluded, the present statute would make a special exclusion to that, an explicit exclusion would be made. In case a specific exclusion is not made and it is not explicitly defined, then we would consider it. We would consider the other acts which have already been prevailing in the country. So considering that whole discussion, we would rather say that the say, secured creditors rankings based upon the security interests, who have renounced their security interests in favor of the liquidation estate, must be respected, and it cannot be challenged unless a decision contrary to that and a judgment contrary to that is delivered by Honorable Supreme Court, and the matter is still pending in sub judice. Further, the intrinsic ambiguity in the topic, as well as the lack of a clear legal precedent, leaves no answer to the difficulty. Since there is no legal precedent to it, no case has been up till date decided on this particular thing. It is conceivable, however, that any priority rights connected to a security interest state tied to the security interest, and that when the security interest is abandoned, the priority rights associated with the security interest expire as well. Although it appears that lawmakers considered all issues when establishing the IBC's liquidation waterfall, which favored secured creditors, legislators should give equal weightage to the interests of other stakeholders in order to fulfill the IBC's goals. Now, it is just saying that, rather it'll be a good this thing in case the lawmakers would give the other stakeholders also the equal weightage. Whether it is the operational creditors or any such things, in order to ensure that the justice is rather, the distributive justice prevails. However, the historical perspective that we've seen throughout the presentation and throughout the laws that have been governing our country, whether it is the Transfer of Property Act or whether it is the Companies Act initial one or whether it is the amended Companies Act 2013, we all look at these specific provisions which have been given under all cases wherein the the justice has been tried to be delivered. So we rely on Section 53 to be sacrosanct, and it is something to be relied upon under all cases. And the matter of this interstate security, which is still pending with Honorable Supreme Court, we look forward to the decision, and let's see what happens, and what is delivered after that and how it is to be proceeded. So thank you all. I mean, so I'm extremely sorry. I have kind of because of this bad throat, I have rather done some I maybe we could have gone even into more discussion, but I somehow developed this throat just recently, and I just thought, let me just discuss whatever.
Madam, it's okay. Kindly share with us the PowerPoint presentation so that we will, if you want to disturb, we'll disturb you later on.
No problem, sir. In fact, anybody who has any question right now or any observations or any discussion, we can definitely do that. I welcome you in case you have any questions or any observations or any further analysis or any further piece of information which can help us all. I welcome that.
If Mr. Kanti doesn't have anything and I don't have anything, you can close down. All the others are silent spectators.
No, thank you, sir. I'm sure all of have been able to explain the concept clearly, and I'm sure we all have been able to understand it. In case there are any questions even further, I'll share the presentation, and you can contact me anytime. Yeah, thank you so much. Thank you. Over to you, ma'am.
Thank you so much, ma'am. Even with the bad throat, you were ready to take the session today. So thanks a lot for sharing your knowledge with all the participants. And we will invite you for other session as well in future. But at the moment, you please take care of yourself. And thank you so much for being present here today.
Thank you all. Thank you all for being here. Thank you so much. I look forward to your questions or to your observations. Thank you. Thank you.
Thank you, ma'am. Thanks to all the dear participants.
Thanks.
Madam, are we taking a short break or another session will start?
So this session is wind up today as ma'am is not doing very well.
Okay,
So,
great.
Close it
Thank
up.
you.
for today, and I'll share the PPT with everyone once I receive it from ma'am.
Yeah, please do that.
Okay,
Thank you.
Thank you.